Hello, everybody. Sorry to cut your break short. We'll be getting on with Professor Kalt. Welcome and thank you to everyone for coming. My name is Tori Donovan. I am a 3L JDMA student at the College of Law. I am also an article editor for the Law Review this year, and I've had the privilege of working with Professor Brian Kalt on his article, CJ Box and the Yellowstone Zone of Death. So here's some background on Professor Kalt. He's a professor of law and Harold Norris Faculty Scholar at Michigan State University. His scholarship centers on constitutional structure with influential writings on presidential power, succession, impeachment, and jury systems. His work has been cited across courts, scholarship, and public commentary, and he is also the author of The Perfect Crime, which is his first writing on the Yellowstone Zone of Death. So today he will be talking about the jurisdictional loophole in Yellowstone where crime is seemingly unpunishable. This article will be featured in the upcoming Wyoming Law Review CJ Box Special Edition, so please help me welcome Professor Brian Kalt.
Thank you, Tori, and to the Law Review for having me here. There are not many things that would get me to come out somewhere on a football Saturday. Football has the features of a religion in a lot of ways, and today is the day of holy obligation. So no spoilers. My team is kicking off as we speak. But I am glad to be here, and in writing this article, remembered back to one morning in January of 2006. I had just written the Perfect Crime article, and I received an email about it from someone that I had never heard of before. The Perfect Crime, as we'll discuss, is about a quirky legal loophole. Some criminals might be able to escape punishment for major crimes they commit in a 50 square mile so-called zone of death in Yellowstone National Park. And the key passage in the email said, I had intended to use Yellowstone as the setting for my 7th novel and was looking for the right hook, i.e., how in the hell do I get a Wyoming game warden into Yellowstone and why? I think you know where this is going. You and your paper helped provide the framework for the new novel, which is being written right now and will likely appear May of 2007. And that was my introduction to CJ Box and to Joe Pickett and to the novel that eventually became Free Fire. And CJ Box's instincts were right. The Yellowstone Zone of Death theory turned out to be a great way to get Joe Pickett into Yellowstone. I want to start by laying out the theory for those of you who might not be familiar with it or maybe got your information from TikTok or YouTube videos instead of from Free Fire. Yellowstone, as most people in this neck of the woods know, is mostly in Wyoming, but has some parts in Idaho and Montana. This doesn't present any sort of problem in itself. There are plenty of units of the national park system that cross state lines. But the country is also divided up into judicial districts, district courts. I live in the Western District of Michigan. Most districts are either a state, like the District of South Carolina, or a part of a state, like the Western District of Michigan. None of these districts cross state lines, except for one. The U.S. District Court for the District of Wyoming has jurisdiction over all of Yellowstone National Park, including the portions in Idaho and Montana. And the districts for Idaho and Montana exclude those states' portions of the park. In other words, the Idaho portion of Yellowstone, the so-called Zone of Death, is in the state of Idaho, but also in the federal judicial district of Wyoming. The problem that this creates is teed up further by the fact that the federal government has exclusive jurisdiction in Yellowstone. A lot of federal lands have concurrent jurisdiction with the states. If a crime happens there, the feds can prosecute or the states can. Not so in Yellowstone. Only the feds can prosecute crimes committed in Yellowstone. So currently, if a crime is committed in Yellowstone, they are prosecuted in the District of Wyoming. The district has courts in Casper and Cheyenne, on the other side of the state from Yellowstone. Its trials use jury pools from Wyoming. The district does have a small court inside the park, but it's only used for minor crimes. Jury trials go east. There are two constitutional provisions at issue here. Both of them are very simple. Most constitutional provisions are not, right? Most of them are subject to interpretation. These are not. The first one is Article 3 says that all federal criminal prosecutions have to occur in the state where the crime was committed. So you see the problem with having a Wyoming trial for a crime committed in Idaho or Montana. Of course, this is easy enough to fix. There are plenty of courtrooms in Idaho and Montana. But then the Sixth Amendment says that the jury in these trials has to be from the state and district where the crime was committed. In other words, a crime committed in the Idaho portion of Yellowstone has to be tried in front of a jury that is from the state, Idaho, and the District of Wyoming, where the crime was committed. The only way that, the only easy way that people could be from both the state of Idaho and the District of Wyoming is if they live in the Idaho portion of Yellowstone, but nobody lives there. The result of Congress coloring outside the lines here is, I say, that anyone that they try to prosecute for a major crime would be able to say, this violates my Sixth Amendment rights. You need to let me go. I'm not happy about that, but that seemed to me to be the situation. A couple of caveats, limits, and explanations. First, you would think, oh, well, if this ever happens, and it hasn't, so that's the first thing to put out there. If it ever happens, Congress can just redraw the lines and apply it retroactively, but they can't. The Sixth Amendment specifically says about these judicial districts that they shall have been previously ascertained. In other words, the one thing they can't do is redraw them and apply that retroactively. They could certainly redraw them and apply it prospectively. They could fix this problem in 5 minutes if they wanted. Another thing that I hear people say is, well, why wouldn't they just do a change of venue? They do changes of venue all the time. Under the federal system, Federal Rules of Criminal Procedure, Rule 21, the only way you get a change of venue is if the defendant asks for one. The prosecution can't ask for a change of venue, and the court can't order one on its own motion. So change of venue wouldn't work. Some people say, well, they could just put you in jail until they figure it out. Yeah. Sixth Amendment also gives you the right to a speedy trial. That's not going to work. There are also important limits, though. One is not every crime gives you the right to a jury trial. Class B misdemeanor or below, 6 months of jail or less, you don't have a right to a jury trial. So they could get you for that. More pressing, I think, and more limiting is that they could charge you for a crime that you committed somewhere else. It's pretty hard to commit a crime entirely in the Idaho portion of Yellowstone. If you planned it with someone else, somewhere else, they could charge you there for conspiracy. If you enticed or tricked or forcibly dragged your victim with you into the Idaho portion of Yellowstone, well, they could get you for kidnapping, where the kidnapping started. So it would have to be a crime committed entirely in the Idaho portion. Another common suggestion that I've heard is, well, why couldn't they just do a split jury? Like have some of the jury be from Idaho and some of it be from Wyoming? The short answer is that's not a thing. You can't have jurors from multiple districts. But it also reflects, that reality reflects the way the Sixth Amendment has traditionally been interpreted. And my response to that is, wouldn't it be easier, instead of rewriting the Sixth Amendment so that now everywhere the jury doesn't all have to be from the right district, why not just fix it? Why not just fix it? That's my recurring theme here. None of this is a reason not to fix it. There is one objection, one limit that people always raised and always still raise, and that bothered me to no end, in part because it was correct, but in part because of what it says about our system. And that is, people say, well, they wouldn't just let someone go. And my reply to that is, that's not a legal argument. And it's not, but as we'll see, it is potentially a pretty effective one. But before we get to that, I do want to talk about C.J. Box and Free Fire and the contribution that Free Fire made to this theory. My purpose in publishing this article was not to inspire would-be murderers. I had them delay publication so I could try and get Congress to fix it before the article came out. They did not reply to my communications. So it came out about a year later, and there was a lot of media attention. I was on NPR talking about it. There's a bit in the National Enquirer that sort of runs the gamut, right? And it was, I think, on one of the public radio appearances that Chuck Box heard me talking about it and decided that this would be his hook to get Joe Pickett into Yellowstone. And he contacted me and asked if I could help him out, and I was happy to do it. He was very interested in getting it right, in getting the law right, and getting particularly the details. The first contribution he made, though, was that he actually knew the area. You know, I'm a law professor in East Lansing, Michigan. I'd been to Yellowstone when I was a little kid, but I'd never been to the Idaho portion. I didn't know that this was a real possibility. Well, C.J. Box had been there. He'd been to the Idaho portion. He knew the area like the back of his hand, and he said, yeah, you know, people go there. Crimes could happen. Someone could do something. Something else that he did, though, was he asked around. He asked one of the federal judges here in Wyoming, and that judge said he didn't want to write a book if there was some obvious reason why this was wrong, and the judge said this could pose an effective defense. And he talked to some employees at the park who, he reported to me, said that the theory, quote, scares the crap out of them, unquote. So this reassured him that the premise was sound enough to use for his book, but it also reassured me that there was actually something to this, that there was a reason to try to get this fixed. Then, of course, there's the great contribution of actually dramatizing this. I want to avoid spoilers here for any of you who haven't read the book. I think you all should, but read the book. But in case you haven't, when I came out with this article at first, a lot of people said to me that it would make for a great novel, and I would always agree, and I'd say the problem is I would not make a great novelist, but C.J. Box already was. And so the dramatic opening to the book, I think, reflects this. A half hour after Clay McCann walked into the backwoods ranger station and turned over his still warm weapons, after he'd announced to the startled seasonal ranger behind the desk that he'd just slaughtered 4 campers near Robinson Lake, the nervous ranger said, "Law enforcement will be here any minute. Do you want to call a lawyer?" McCann said, "You don't understand. I am a lawyer." Then he smiled, as if sharing a joke. And if that doesn't make you want to read the rest of the book, I don't know what would. Of course, this gets, for reasons that I won't spoil the plot with, gets the governor involved, and he gets Joe involved, and Joe gets Nate Romanowski involved, and there's good opportunities for some exposition where Joe explains the zone of death theory very accurately to Nate, and some of the limits come up. Nate says, well, what if I grabbed you right now and drove you up to the Idaho part of the park and put a bullet in your head? Joe says, no, they get you for kidnapping, right? They also made the point that doing anything there would still be a crime, right? It's not that it's not a crime, it's that there's no way to punish it without violating your constitutional rights. That's something that some of the YouTube videos gets wrong. It's a section in Idaho where crime is legal. Well, maybe there is, but not that one. There's also Clay McCann commits some more murders, and they reflect his increasing desperation. But what I thought was great about the dramatization of it was that his description of the crime was that it was a spur of the moment a crime of passion, right? He's just there, and these people are picking on him, and he gets mad and he kills them. And that's exactly the sort of situation where the loophole would apply. He didn't conspire somewhere else to do it. He didn't kidnap someone to bring them there. There's also, sometimes people say, oh, well, if you commit murder, they can try you where you formed your intent. That's under federal law not true. The venue has to be where you did the crime, and he said that's where he did the crime. There's also potential for civil liability, of course. If you kill someone, the state could sue you, and that's dealt with in the book as well. He addresses that too. I really appreciated his commitment to accuracy and working with me and fixing the little things just so that it was right. And he did. He warned me early on that, as he put it, that the novel might cut some legal or procedural corners in the pursuit of pace and plot. But he really didn't. There's only one. There's only one. And that is that in Free Fire, when Clay McCann asserts his defense, the prosecutors and the judges say, I guess we got to let you go, which is not what real-life prosecutors or trial court judges would do. I understand, for the purposes of dramatization, why you don't want to have a multi-year sequence of appellate litigation in a Joe Pickett novel, but that distinction between just letting him go and not just letting him go is at the heart of the deeper meaning of the zone of death theory. One final effect that Free Fire had on the zone of death theory was popularizing the phrase zone of death itself. In the article, I called it the Idaho Parkland, the Idaho section of Yellowstone, the Idaho portion of the District of Wyoming. In one and only one place, I referred to it somewhat flippantly as the zone of death. And Free Fire picked up that phrase and ran with it early on. C.J. Box knew a catchy phrase when he saw one. And before Free Fire came out, none of the discussion on NPR or the Inquirer or everything in between used the phrase zone of death. And after Free Fire, pretty much all of it does. There have been other portrayals, right? The show Yellowstone has the train station, which is not based on my theory directly, but they have a different version of it, which they're not worried about keeping it precise or anything, and that's fine. There's been a lot of speculation in the Gabby Petito case, the Lori Vallow case that happened in and around Yellowstone. People thought, oh, maybe there's an angle there. And so there's been a lot of attention because of that. And so tens of millions of people have watched these YouTube videos, TikTok videos. For this article, I had to go watch them I limited myself to the ones that had at least 1 million views. And there were, at that point, 14 on YouTube, 7 on TikTok. And some of them were pretty good. A couple of them went into the zone and gave us the video version of the great descriptions that Free Fire had in prose. But most of them aren't. They say they don't talk about the limits or the caveats. They don't explain the theory really at all. And so Free Fire still looms as the best treatment so far. Now, the question I get most often is, why haven't they fixed this? And that's a question I ask myself too, a lot. As I said, the first attempt I made to get Congress to fix it, Congress ignored me fairly impressively, thoroughly, right? Like usually if you write to your member of Congress about anything, they'll at least acknowledge your letter, right? If I wrote to McDonald's about the Yellowstone zone of death, they would have thanked me for my letter, sent me a coupon for some McNuggets, but Congress, not so much. When Free Fire came out, though, one of the biggest fans of the Joe Pickett novels was the late Senator Mike Enzi. And so when he read Free Fire, now I started getting replies, right? He wanted to look into it, and he did. What he found, though, was that the Department of Justice did not want to fix this. They gave 2 reasons. One reason was that they didn't think that it would hold up in court because, as they put it, they would just say that it was harmless error. The harmless error doctrine, though, does not apply to structural errors like this, right? I mean, this is a fundamental right, Sixth Amendment right to a trial. But more bothersome than that to me was that they were basically saying, look, if this ever happens, we will do this thing that we know is wrong because we don't think that it matters. We don't think that having the jury be from the right place matters. We don't think that state borders matter. That seemed odd to me because, again, it would be so simple to fix. The other reason that they gave was that it wouldn't be so simple to fix. They were concerned that if they put part of Yellowstone in the District of Idaho and part of it in the District of Montana, that would put part of the park in the Ninth Circuit. Back then, not the case anymore, but back then the Ninth Circuit was the crazy liberal circuit court, and they didn't want all of these environmentalists bringing lawsuits challenging park management decisions to be able to bring those in the Ninth Circuit instead of bringing them to the rock-ribbed conservative 10th Circuit. But that didn't make sense either because the Sixth Amendment only applies to criminal trials. There's nothing preventing them from specifying the venue in any administrative law issues involving the park would go to the 10th Circuit. In fact, I found Ninth Circuit cases dealing with Yellowstone management issues already. So if anything, this would have fixed the problem for them. But, and Senator Enzi agreed that the harmless error argument wasn't particularly edifying. But he wasn't going to spend the political capital that it would require to try and get legislation passed over the Department of Justice's objections. And in particular, if this is just a hypothetical situation, right? Congress deals with things where powerful interest groups are losing money or being hurt in some way. No one's ox is being gored here. No one's interests are at stake, other than perhaps a somewhat obsessive, compulsive law professor who doesn't like when people color outside the lines. No crimes were committed before I wrote my article in the Idaho portion of Yellowstone, and none have been committed since. It's a remote corner of the park. It's not connected to the rest of the park road system. It is the least visited part of the park. There are no thermal features there. People go there, but they don't tend to kill each other. The other factor that I hadn't really considered, and I should have because it's somewhat obvious, is turf. The governor, Matthew Meade, at the time that he said this, had been the U.S. attorney, and he said that he didn't want this fixed because Wyoming likes having control over all of Yellowstone, right? It's their turf. And I get that, but I thought, well, maybe Idaho has something to say about this too. And in fact, the Idaho state legislature has passed a resolution asking Congress to fix this. Probably the most surprising response was from Senator Risch of Idaho, who said that this was, quote, science fiction, unquote. I'm not sure what the science part was, but I disagree with him on the fiction part. He was premising that on the notion that the state could prosecute any crime that happened there. And I found that mind-boggling because not only had he been the governor, but he had been if I'm not mistaken, the attorney general of the state as well. So if anyone would have known, well, no, he wasn't the attorney general, he was a prosecutor, not the attorney general. But if anyone should have known that the state has no jurisdiction in Yellowstone, it would have been him. There has been a case, and I want to conclude by talking about that case. The case arose in the Montana portion of Yellowstone, which you'll notice I haven't said anything about. And the reason I haven't said anything about it is because there are actually people who live there. There aren't many, and it might be hard to pull a jury together from them, but there are some. And not long after my article came out, a gentleman by the name of Michael Belderain was arrested for poaching. He shot an elk that he shouldn't have. He was apparently standing in the Montana portion of the park when he did it. He was also a felon in possession of a firearm, which ended up being a much more serious penalty than the poaching. But he was prosecuted, and when he committed the crime, he didn't know that this theory existed, but his public defender did and raised the defense. Now, again, there is no question that the Constitution says if he was in Montana, the trial needs to be in Montana, not in Wyoming. And the jury needs to be from Montana and from the District of Wyoming. But, maybe you could do that. Maybe you could cobble together enough people. The judge in the case was, I don't know if he had read the responses to my article or not, but he reflected them. He said, and I'm paraphrasing here, but not simplifying. He said that, yes, that is what Article 3 and the Sixth Amendment say, but I can't just let him go. Right? That was his decision. First of all, that wasn't true, right? I mean, they could have tried to have the trial in Montana, send it over there. In fact, they could have prosecuted Belderain in Montana. So there was really nothing at stake in letting this case go. He did the things that he did on the other side of the district boundary too. So you would think in a case like that we would have appellate review. I can understand why a trial court judge isn't going to say, yeah, let's let criminals go free. That's just the way to advance my career. But the 10th Circuit, you would think, would take a little more time, at least give a reason. In my original article, I said, look, there are ways that you can interpret the Sixth Amendment. This is constitutional law. If you want a certain result, you can find some theory somewhere to dictate that that's exactly the result, right? So you can interpret the Sixth Amendment in different ways to mean things other than what it says, right? That's what lawyers do. If what it says isn't good for your client, then find some other way to look at it. They didn't say that. So appeal it to the 10th Circuit. Maybe the 10th Circuit will figure out a way to close this loophole, and then it'll be closed, great. Or maybe they won't, and at that point, Congress will do something about it. I was disappointed with what the trial court did because, as I put it in a follow-up article, the point of the Constitution is not to put people in prison, it's to put limits on the government. The judge's job is to protect the Constitution from statutes that violate it, not to protect prosecutors from the Constitution. So what happened next was even more disappointing, and that was that the U.S. Attorney's Office made a plea deal with Michael Belderrain. And they said, we will recommend a lower sentence, and you will not appeal this issue to the 10th Circuit. You can appeal other stuff, and he did, and he lost, but you cannot appeal the Yellowstone loophole. So the signal they sent, I think the signal they thought they were sending was, try this and you're going to get convicted. We are still going to prosecute you and you are still going to prison. And he did. He went to prison for 4 years. But I think they also sent a signal that there was something there that they didn't want the 10th Circuit to look at. And this was a case involving a poacher, not a murderer like Clay McCann. Unlike the dastardly Clay McCann, Belderrain didn't know about the loophole when he did it. He wasn't eager to take advantage of it. He was remorseful for his poaching. There was a good podcast about all of this. The podcast is called The Experiment. And they interviewed Belderrain, which was great because I'd never heard his side of this. And there's this passage here I want to read to you. So they have him saying, I mean, did I deserve to get in trouble? Absolutely. I mean, what I did was the dumbest thing ever. You'll never hear me say what I did was right. No lawyer would have gotten me out of it, nor should he have. Anyone that knows me knows I bleeped up. Oh, excuse my language, knows I did wrong. If someone else would have did what I did, I'd have beat him up, put it that way. So he took the plea deal. Now consider by contrast a real-life version of a sociopath like Clay McCann, facing a quadruple murder charge. He would have a much greater incentive to roll the dice. As Belderrain himself indicated, it's a good thing, not a bad thing, that he was convicted of his crimes. But it is a bad thing that it was done in a way that left the loophole as wide open as it had been before. In thinking about this, I wrote. I'll just read you my conclusion. I won't try and dress it up. The Yellowstone zone of death is firmly embedded in the public consciousness. C.J. Box's Free Fire is a major reason why. Indeed, the novel is probably the most useful thing that has come out of this whole mess. 20 years after The Perfect Crime was published, Congress has offered no response, and the criminal justice system has offered only a very cynical one. One can imagine Joe Pickett's response to all of this. And I just want to preface this by saying that I asked C.J. Box if it was okay for me to put words in Joe Pickett's mouth here. And he said it was fine. Picture someone telling Joe not to worry about the zone of death because Michael Belderrain went to prison. Joe might point out that Belderrain only went to prison because the trial judge refused to enforce the Sixth Amendment and because the prosecutors kept the circuit court from considering the issue on appeal. While Joe surely would be glad that a poacher was held accountable, it's hard to see him being too happy about the way the loophole still looms, waiting for a worse criminal with nothing to lose. I hear him saying something like this. So now it's a dare. All it takes is higher stakes, someone more vicious, colder, someone who actually wants to test it. This country is built on the idea that we follow the law even when it's inconvenient. But when the people running it cherry pick what to follow, that's when the cracks start showing. Now, if there were a list of the 1,000 biggest problems facing the United States of America in 2025, the Yellowstone zone of death loophole would not be on it. But the problems that it embodies, I think they might just be. On that note, I would love to take your questions.
So I know the idea of hiving off the Idaho portion into the District of Idaho has been rejected, and similarly, District of Montana. Has anybody considered, or have they also rejected thoroughly the idea of making jurisdiction concurrent with the state authorities in Montana and Idaho, and not doing that in Wyoming?
So I think they're even less willing to do that because getting the state involved in anything to do with Yellowstone would be a huge imposition. I think just letting the state come in for criminal law purposes would, and maybe only doing it in that part. I think that would be a much easier sell, but they've shown no interest in it, and Idaho hasn't asked them to. But that would be an easy fix, and I do think there is. I mean, you could argue that they could even do that retroactively. I don't think so. I think that would be ex post facto. But no.
What specifically is the fix that needs to happen? What was the fix Senator Enzi was trying to do? And this isn't a question. If I can just give a comment real quick. I've worked for the county attorney's office in Teton County for 25 years. We have concurrent jurisdiction with Grand Teton. I don't know if I should share this, but we actually meet with Yellowstone every year. We actually take a lot from them. Perhaps not a lot of criminal, but like the feds don't have any ability to do involuntary commitments. So Park County, which is Escoric up there on the Cody side, we split Yellowstone at Fishing Bridge. So anything south of Fishing Bridge, I take their Title 25s. We take juveniles because there's a lot the feds just don't do. And we go to Mammoth probably every 2 years and sit down and meet with them. And so there is a lot of cooperation. I'm not saying we're actually doing a lot, but we work with them pretty closely just because the feds don't have a lot of things that the state has, and particularly when people have mental health issues in Yellowstone, the rangers bring them to us. I'm not sure they were supposed to be doing that, but they do. Anyway, I was just curious what the fix would be if you wanted to do this fix over. I assume this mostly over at Belcher Falls over there on the Idaho side. I mean, and I'll just tell you. I mean, we meet. Fremont County, Idaho, which is in Ashton, is where you're talking about essentially. We go over and meet with them probably every 2 years. And anyway, there's a lot of cooperation. I just didn't want you to think that we don't all cooperate up there. We meet all the time, and so because we're all affected by mostly. I mean, we collect lodging tax in Yellowstone, so I'm constantly up there because our county has to collect because I do the civil side, and so we collect a lot of money. And it's a big deal between Park County and Teton County because we know where the line is. Because if the Park County knows, if it's Canyon or Mammoth, they're collecting the money. If it's Lake Hotel, we're collecting the money. Or Grant Village, we collect the money. So I just wanted to make sure you knew that there's some cooperation, not a lot, but some.
Yeah, the key phrase though was civil side, right? And so the fix would not require amending the Constitution. It would just be redrawing the district lines. So 28 USC 131, instead of saying the District of Wyoming shall consist of the state of Wyoming and those parts of Yellowstone National Park in Idaho and Montana, it would just say the District of Wyoming is the state of Wyoming. And similarly, the statute for Idaho would just say the District of Idaho is Idaho, instead of the District of Idaho is Idaho except for the Yellowstone part, and the same for Montana. So it would just be making those district line statutes look like every other district line statute, and then maybe having the thing at the end about the venue being in the 10th Circuit instead of the 9th if they're still concerned about that.
Unless there's any more questions from the audience, I do have some online. All right, I'll move online. Professor Kalt, what historical reasons underpinned the drawing of the District of Wyoming's borders? Does the legislative history show awareness of the Yellowstone zone of death?
It's much better than the online comments and questions I usually get. So I think it's interesting historically to look at fact that Yellowstone was made a national park before Wyoming, Idaho, and Montana were made states. And so the borders reflect that. I don't know why they didn't make the borders of Wyoming include all of Yellowstone. I guess they liked having the straight lines. But that's the main thing. And then also, because it's federal and because there was exclusive federal jurisdiction, there was a problem of not having enough law. Generally speaking, you murder someone, it's not a federal crime. There has to be a federal hook to it. So they incorporated state law into federal law. So if you're in Yellowstone and you do something that's against Wyoming state criminal law, then you've just violated federal law and they can prosecute you federally. Initially, they applied Wyoming state law to the entire park. But now it's clear that it's Idaho law that applies in Idaho and Montana law that applies in Montana. So I don't know. I think it might just be inertia. It might be not really thinking much about the Sixth Amendment right, and that's what brought me to this topic. This right to a local jury is one of the very few rights in the Bill of Rights that doesn't apply to the states. Everything else, it said, First Amendment says Congress can't impinge your freedom of speech, but it's been applied against the states. Everything's applied against the states. This one isn't for some reason. And so they just weren't thinking about that, and they wanted to manage it as one unit. But again, there's plenty of units in the park system that are that go across state lines.
Thank you. Can you please tell us what initially motivated you to research such a narrow but fascinating jurisdictional anomaly?
So I like to say there are two kinds of people who think about this sort of stuff. There are sociopaths who want to get away with the perfect crime, and there are neurotic people who are worried about the sociopaths. And I'm squarely in that second group, although that's probably what a sociopath would say too. I don't know. I was writing something about the disregard for the Sixth Amendment right to a local jury trial in a completely different context. And I didn't have tenure, and I hadn't gotten any articles out that year, and my wife was about to have a baby, and I wasn't going to get the article done. And I said, well, there's this little footnote here. Maybe I can do something with that. And the guy in the office next to me is from Montana, and he said, the feds have exclusive criminal jurisdiction in Yellowstone, so this is a bigger problem than you thought. And I said, okay, so I can write this over the weekend. It's a short little, by law review article standards, very short. I wrote it, got it out, got it accepted. The baby was born. Eventually, I finished that other article. No one read it. But it was thinking about the Sixth Amendment and the disregard for it. And I kept seeing these references to the Wyoming district borders, and they would always say, but this is of no consequence. And I thought, well, yes, it is. And so there I had it.
This is working. Oh, it's working. All right, I think we have time for maybe one more question.
I'll be quick.
All right. Has social media and the pop culture attention to the zone of death helped or hindered serious legal discussion of this legal issue?
I think it's had no effect, honestly. I don't think there has been serious legal discussion of it. There's the theory. There's really been no convincing legal comeback to it that I didn't already have in the original article. The only comeback is they wouldn't just let him go, which apparently is true. And I don't know. I do think the social media attention has made it well known. Like I said, millions of people know about it, but I wish that more people were getting their information about it from Free Fire than from TikTok. And that'll have to be the last thing I say about that.